All right. Sounds like we're ready with our electronics. Would you join me? We'll start with a prayer and a pledge of allegiance. Would you stand, please?
Lord, we thank you today for this beautiful day you've given us, Lord. I pray you be with each one of us as we make decisions for our county, Lord. Please protect all our first responders today in our county, Lord, and heal our land, Lord, of this virus. And pray you keep blessing Titus County like you're doing, and we thank you for all of that you're doing for us, Lord. In Jesus' name, amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good morning and welcome everyone to Commissioner's Court, November 8, 2021, just after 9 o'clock, despite what our clock says. And we will begin with item number 1. This is public comment time. Anyone here that would like to address the court on non-agenda items in accordance with our Open Meetings Act? And again, you can speak on any agenda item as we get to those. Anyone with general information that wants to speak, this is your opportunity. Sue? Let's see if she's going to have something first here. She raised her hand first.
Well, good morning, Judge Lee and Commissioners. You probably know my name, but for the record, I'm Sue Evenwell, and I'm here representing myself as well as the Titus County Republican Party. I've given you a packet of documentation, and it's in the order that I'm going to talk about what I have to say this morning, so you can just follow along. The first is a letter. So earlier this month, a Texas citizen got this letter from President Biden notifying them of a check of $1,400 to be given to them by direct deposit from the American Rescue Plan. Reading in the highlighted areas, it's clear what the intent of the American Rescue Plan is all about. Quote, on March 11th, 2021, I signed into law the American Rescue Plan, a law that will help vaccinate America. And it continues down to the bottom to say, we are on the path to vaccinating the nation. Now, we don't have to have a big discussion about vaccinations today, except to say you need to know that I think that decision of being vaccinated is a choice that an individual should make, and it should not be a government mandate. I got involved in this, looking into this, because of Senate Bill 8. It was recently passed in the 3rd legislative session, and it's now sitting on the governor's desk to be signed. I want it vetoed. It is basically the distribution plan for Texas for $16.3 billion from the coronavirus state and local fiscal recovery funds from the American Rescue Plan of 2021. This money, however, came to Texas with a contract, and it made me wonder if Titus County might not be also getting a contract for the funds it received, because it's my understanding that Titus County will receive a total of $6 million. A little over $3 million of this free money has been received, and a tranche for the rest is coming in April, I guess after taxes are collected. And I probably know in some minds it's already been spent, but none of it has been allocated just yet. I'd like you to read the fine print in the contract that I gave you. This is what Texas got along with the money. And look at page 3 on section 9. It says, the recipient also agrees to comply with all applicable federal statutes, regulations, and executive orders, and recipient shall provide for such compliance by other parties in any agreements it enters into with other parties relating to this award. Will the inclusion of executive orders for terms of compliance found in the various coronavirus fund distribution programs now be the means to control transferred from control from the state and the local governments to the federal government by consent of contract? Ken Paxton, our Attorney General, was concerned about this too, because the letter from him you also have, dated October 15th, 2021, he warned the state agencies of the federal contract language causing conflicts between the state and federal laws. And I highlighted the critical language for you. Quote, President Biden recently issued a federal executive order directing federal departments and agencies to begin including a clause in federal contract and contract-like instruments specifying that contractors must comply with workplace protocols and would apply to all covered contractor employees, including contractor or subcontractor employees, and these protocols will now include an agreement that covered employees receive a COVID-19 vaccination. Now, read the back page too, and I won't go into it, but does this mean, if we have a contract like this, that Titus County, if we accept this funding, all companies doing business with Titus County must comply with vaccination mandates? I don't know, but I think we better be sure before taking that money, because I'm not willing to compromise liberty. Now, some will say the feds can't come into a sovereign state like Texas and subvert our laws with federal funds via contract. That's what the 10th Amendment really is all about. But I have never seen the state challenge it, and the federal government does come in and take that law away, or take those laws and use them against us. For instance, the state says we do not teach critical race theory in our schools, but I can show you plenty of evidence that I have found recently that federal tentacles are being used to bring material into our schools about CRT without the approval of our State Board of Education. It's in our classrooms right now. Texas also has private property laws to protect landowners, but federal transportation dollars corrupt that law and allow for land to be condemned, taken, and confiscated. Do you know in Texas there is still a law in the books that marriage is between one man and one woman? But when the Supreme Court ruled otherwise, Texas leaders folded. They didn't have to. And immediately local governments changed the employee handbooks and benefits based on the Supreme Court ruling, thinking it was the ruling of the land. But there's nothing in the Constitution that gives them that power. They have now normalized same-sex couples as legal and eligible for family benefits. There are 65 municipalities in Texas under the population of 50,000 that have actually declined the funding, and you can see the others listed on the Texas Department of Emergency Management. So Senate Bill 8 also speaks of future tranches of funds and how the recipients will be expected to follow federal rulemaking. And that is an ongoing changing thing, and so are executive orders. I haven't fully investigated all of the effects that Titus County would be under. I admit this. The Supreme Court is now considering whether President Biden has the authority to mandate vaccinations. I can't imagine why they have to ponder very much, because the 10th Amendment makes that pretty clear. But before you start spending this free money, please do your due diligence. Find out what it's really going to cost us. Will Titus County residents be forced to comply with mandates from the Biden administration, despite what our legislators and our governor does? This seriously smells like Marxism, which we see a lot of nowadays. The grassroots activists across Texas are asking Governor Abbott to veto SB 8 to protect liberty and stop the advancement of Marxist-style control over individuals, businesses, and corporations. And I'm asking you to decline this funding if it's going to lead to tyranny in our community. I know this could be a hard decision, but on the other hand, you were given our trust at the ballot box. It's your job to protect liberty and liberty's first principles for us. And it's a reasonable expectation that this court will scrutinize any contract with the federal government before committing its citizens in this county. Thank you.
That's actually very good information. I hadn't even thought about this. We do have that money. We haven't spent a dime of it. And please keep me posted, and I'll begin my investigation too. I think that our Council of Governments needs to get involved in this and help us to understand before we get too excited about spending all that money what the implications are here.
I have one extra documentation.
Okay. All right. Thank you. Ross, you ready?
Morning, Judge Lee, Commissioners. My name is Ross Estabrooks. I'm a local business owner, Assistant Fire Chief, Tri-Lakes Fire Department, and 24-year veteran of the fire service. I am a IAFF alumni, local 2881 out of California. I started my firefighting career in 1997 in Canada, worked for the third largest fire department in North America for Cal Fire as a professional firefighter in the early 2000s, and been in and out of the fire service. This morning I'd like to present to you a few details about the cost of firefighting, what it takes for volunteer fire departments to exist, and the support that we need as volunteer fire departments from the county. 70% of all firefighters in North America are volunteers. Think about that number. That's, we have just shy of 2 million firefighters in the U.S., and 70% of them are volunteers. They give up their lives daily and their activities daily to go out and help others. 85% of all fire departments in the U.S. are classified as volunteer or volunteered with paid assistance. That's a huge number when you think about it. And, again, huge commitment by the individual man or woman that is working their daily job. I put together just some brief numbers of some of the hours that are involved in this. Currently, right now, at Tri-Lakes, we sit at 105 runs for the year. If we average that at, let's say, 1 hour per call, some may be longer, some may be shorter, that's 105 hours that we pick up and leave our families and go out. We offer 2 trainings per month at our department, which is 4 hours per training, so that's 8 hours per month. And then we're currently doing state or county-wide training with the city, with Chief McCray and his team. That's another 4 hours, so that's 12 hours a month, 12 months a year, another 144 hours. So we're looking at 249 hours minimum that we pack up when we leave our families and go and do this so that we can protect the citizens of Titus County. Currently in the county, we're roughly about 30 volunteers are fully structural certified. That means that we can go into any fire, any building, any domain, and with the certifications and classes that we have, we can properly work that fire, work that situation. Under NFPA guideline, bear with me, I apologize. It is NFPA guideline 1851. It states that bunker gear turnout gear is considered outdated after 10 years of service. Now, I'm not sure about the other volunteer departments. I can't speak for them here in Titus County, but I can speak for our department that we have no gear that is newer than 10 years. We're being asked to go into fires and put ourselves in situations with gear that is outdated and that the federally mandated organization is telling us that they, if you're a paid department, you wouldn't be allowed to. You'd be asked to sit out until you get new gear. But we're being asked to do so on a daily basis. We're being asked to comply with hose testing, pump testing, air pack testing, making sure that all of our equipment is up to date, and so that we can represent and protect our citizens here in Titus County. But yet we're asked to do so on a $21,500 budget per year, which is less than 1% of the budget that our city comrades get. Now, I understand that we're not going to get the same budget that the city department will get, but we're doing the same job, and we're doing the same training, and we're out there daily to do so. We know for a fact that we have volunteer fire departments or firefighters in this county that could walk into a paid position any day of the week because of the training that they've had. So I wanted to make some of these things known to our folks here in Titus County, because I think it gets left out sometimes of what really is involved in being a volunteer firefighter and a volunteer fire department. NFPA states also, for 500 people per square mile, that a responding department should have 6 staff and should be able to respond in a minimum of 14 minutes. Now, I can assure you that our departments, our volunteer departments, are responding with, majority of the time, more than 6 staff in a lot less than 14 minutes. We're ahead of the curve on that. We have an amazing group of volunteers in this county. Inflation, we've seen inflation go up in numerous years, yet the budget for volunteer fire departments in the county hasn't gone up in 10 years. Our fuel bill last month was $685. That's over half of what we're allotted per month. Then we have our lights, our building costs, all of our other expenditures that we have. Where do we get the money for new turnout gear so that we can comply and be safe and know that the people we're sending into these burning buildings are going to be fully protected? We apply for grants, but to give you an idea on grants, we applied for grants in 2010. Now, the benefit that we have at Tri-Lakes is that our leadership hasn't changed in over 10 years. So when our chief applied for these grants in 2010, we actually hit the jackpot last year because 11 years later, they came to fruition and we got some of them. Now, if we have to wait every 10 years to get new equipment, or if we have to wait every 12, 13, 14 years to get new equipment, at what cost is one life? Whether it be the people that we're trying to save or one of our firefighters. I know this isn't budget time, but I'm passionate about the fire service. I'm passionate about the people of Titus County. And at what point do we, allocate funds elsewhere and not give us the proper equipment? For the approximate 30 people that we have that are structure certified, it will cost the county, if they choose to do so, about $75,000 to give us whole new bunker gear that would be good for 10 years. Allow us to be well equipped and properly equipped to do the job in Titus County. The comment was made to me that, well, we don't expect the volunteers to do the job of the city fire department. Then why are we here? Why do you have us at all? I guess that's my answer to that question is, what if you don't expect us to do the same job, then why have us at all? Why are there 6 departments spread around the county? Anyone want to take a stab at that one? I'd love to know the answer. Why are we here?
Well, I think you're here to supplement and lead and provide support for the professional firefighters with the department. I think that each volunteer department absolutely serves a purpose within that community. And depending upon their level of training, their ability to attend an event, they can be some level of support for the Mount Pleasant Fire Department. But recent years have shown that the Mount Pleasant Fire Department is having to play a larger and larger role.
Okay. The numbers that are presented on a monthly basis to you on the amount of support that is given by the city don't speak to the actuality of the situation. For instance, there's numerous calls that are showing that they respond to our district, yet they don't leave city limits. Their tones go off and they start to get into their vehicles and head our way. But it's our first responders and fire department that handles the situation and lets them stay in the city because we're qualified and we're trained to do so. So that's a piece of the puzzle that I've noticed as going back in previous meetings that isn't relayed to y'all. We're pretty self-sufficient in our district, and we're working to help the other departments become self-sufficient in their districts, which the volunteer department should be. Volunteer departments are more than PR pieces and chili suppers. We're more than national nights out and handshaking. We're there when the lights go out, when the storms roll through. We're there cleaning roads off to help our commissioners when the trees fall. We're there to comfort those when they lose their loved ones. We're as frontline as frontline's going to get. And then we turn around and go home to our families, bearing that weight. We don't ask for a paycheck, and we don't ask for a thank you for your service. It's what we are happy to do and proud to do. We're proud to serve the people of Titus County. We're proud to serve everybody in our neighborhood. They're our friends, they're our family. Volunteer departments are volunteer departments. We're just unpaid professionals. That's it. I appreciate your time this morning, and as we go forward in Titus County, I ask that the commissioners in this court seriously look at volunteer fire departments as just that. We're unpaid professionals. And we really need your support.
Ross, would you spell your last name for me?
Sure, yeah, it's ESTABROOKS.
Estabrooks, got it. Thank you, Ross. Appreciate it. Enjoyed meeting you the other night. Come back anytime.
Thank you.
Anyone else? There's Colton House. Welcome, Colton.
Yes, sir. Good morning. And once again, I'll say for the microphone, Colton House, I'm here on behalf of the Sugar Hill Fire Department. I had the date wrong on my calendar. I thought the second meeting was the update for Sugar Hill, so I apologize to the commissioners. I had the wrong date down. Just a quick rundown and update. We now have, even with tragically losing one of our own, we are back to 16 members on the roster with one new application. We have air packs that have been inspected and certified by MES Fire. We have voted on the purchase of new air tanks that have about 6 to 7 years of life left if we can. We have to see if they're available. The company may not have them available. If so, then we'll have to lease them out from that company. All of the extinguishers have been checked and certified. The hoses, we had voted to have a company that went to Talco to test theirs. We actually took the engine to Talco and had them test all of our hoses. We took the hoses off the brush trucks, put them on the engine, and had them test those as well. It's the same company Mount Pleasant uses, from my understanding. John has told me that he should be getting with the county auditor to get budget and as well as run sheets and everything turned in properly. We are working on having some paperwork worked out with the state. I believe we had two people. I believe we still had Michelle and Levon Herron on the roster, so we're going to be updating that with the state. Also, just quick update as far as training. I did speak to our members our last meeting night on the importance of training. We also were able to approve me to go through a trainer course for TCFP. Those of you that don't know, I am certified with the state as a career firefighter. I just currently work at the 911 dispatch center here in town. So they did approve me to go through the TCFP trainer courses to where I would be able to provide training, much like Tri-Lakes or Mount Pleasant does. Also, if I could make a comment to the previous statements, I can back Mr. Esterbrooks up on the fact that in dispatch we are required to page Mount Pleasant Fire Department on any call that we get, just so that they're aware. If a volunteer department doesn't respond, I believe they have 3 or 4 minutes. If they don't respond, Mount Pleasant will start heading that way. As far as I know, they still count that as a call. They still request their times anytime that we page them out. Even if they don't leave the city limits, they do request their times from the city. But that should be all I have for this morning, unless any of y'all have any questions.
Thank you, Colton.
Thank you.
Appreciate you.
Thank you, Cole.
All right, last call. Anyone else?
I have one thing, Judge Lee. We have gotten a refund from TAC on our health insurance. It's $28,568. There's no guarantee that we will get these every year. This is based on our first fiscal year with them, which was January 1st of 20 through December of 20. They wait until they had their financial statements audited and all those kinds of things. But I just wanted to bring it to your attention. I've not sent you an email about this, and I just got this today and wanted to let you know.
All right. Yeah, I was a bit surprised when I opened that check the other day. That was nice. Yeah, I mean, yeah, I don't think we can expect that every year. I'd be happy with just, minimal increase every year. So. All right. Thank you for everyone's comments. I'm looking at the time, and it is 3 minutes away. I've got a phone call scheduled with a high-priced lawyer who is expecting our call at 10:30. So if I can find something to eat up 3 minutes, I'm going to jump down to item number 6. I'm sorry. Did I tell him 10:30? I got to make sure that I told him 10:30 or 9:30. I don't think we'll go till 10:30, but either way, okay. Let me, why don't y'all give you a report on road work status, and let me make a quick call to Mr. Simon here and see when he's going to be available. So I'm going to start with report from commissioners regarding road work status. No, let's go back and approve the minutes. I completely missed that one. Item number 2, consider and possibly approve minutes from our last meeting. That was October 25.
Make a motion, we approve them.
I think I heard Commissioner Parker first. No? Okay, I think I heard you first. Motion by Dana Applewhite, second by Jeff Parchman. Any discussion on that set of minutes? All in favor, say aye.
Aye.
Okay, let's go on down and let's start our report from commissioners. I'm going to step out and make this quick call. Why don't we start on that end?
Okay. We spent a big majority of last week picking up trees and stuff after the winds that we had, and some that were trying to fall when they had got them down out of the way, and then we've been installing covers that we've kind of put off and waited on, trying to get through our seal coat and everything. So we are pretty well caught up with that. We've still got a few more that we're trying to replace across some roads. Most of those that we put in last week were from individuals that were trying to get their driveways fixed or whatever. So, but we have got all of our equipment at the end of the week last week, got all of our equipment winterized and everything ready to what we don't use during the winter to be put up. So we're ready for that now.
We finished up all of our mowing last week on the county, and we
we started patching and putting in some culverts. When, like you said, we had trees to get up Monday. It blew over Thursday, Friday rather, and it was high wind. And we got, like I said, we're putting in the culverts today and just trying to catch up on their road work.
All right, Precinct 2 has been working on County Road 1070. We had several soft spots we had to dig out, and they reworked those as they got soft during the rain. And then had a lot of trees down during those 2 days of wind that we had, and we cleaned all that up. We did some patching, and we scabbed a few areas on 1165 and 2730. And we also finished up mowing for the season.
We are still working on County Road 1455. We have been doing some cleanup, trees due to high winds. We have been replacing culverts, patching potholes, and scabbing.
Everybody done?
Yes.
Okay, we've got Mr. Jeffrey Simon is available. I'm going to call him here in just a second, but I'm going to skip down to item number 6. Consider and possibly approve a county resolution in support of the Janssen settlement. This is Johnson & Johnson's parent company, to effectuate a resolution of the opioid litigation against the Janssen entities. And I've given you just a brief document here that you can kind of use, and I think Jeff will probably use this as a framework just to discuss this. But again, this is just part of the opioid settlement. It has to do with the one that has already been settled, and again, that's just simply Johnson & Johnson, or more specifically their parent company. So I'm going to get him here on the speakerphone and let Mr. Simon kind of walk us through this. Approve this resolution. Okay? All right, here we go. Okay, Jeff, you're live.
Hello, everyone. Y'all can hear me?
Can y'all hear me out? Can y'all hear him out there? Any way you can turn up that master volume? Just bump it up a little bit. I don't think it starts reaching. Okay, there we go.
So, hello all. I look forward to a chance to meet you in person. There will be other opportunities for us to do that, and I'll make a point to take advantage of it. My name is Jeffrey Simon, and I'm with the law firm of Simon, Greenstone, Panettiere, and I am one of the county's outside counsel in its opioid-related case. The county, like many others, has been hard hit by the opioid epidemic, specifically prescription opioids, which flooded the community over a period of years because of, first of all, misleading marketing by opioid manufacturers who persuaded healthcare providers in our state, in our county, and around the country that prescription opioids were good medicine to treat chronic pain, and that they are safer and more effective to do so than they really are. They aren't. They've never been proven to be safe to treat chronic pain. In fact, they are highly addictive and too easily the subject of overdoses, which too often lead to death. Also, all the way down the corporate supply chain, the wholesale distributors who purchase prescription opioids from manufacturers and sell and ship them to pharmacies, and certain pharmacies, particularly certain retail chain pharmacies, failed to exercise the lack of controls for these controlled substances in the way they should. And as a result of that fact, not only has there been enormous human misery from addictions and overdoses, the dissolution of families, but there's also been a significant economic impact, which is often borne by local communities such as the county. So with your leadership, we pursued a claim against opioid drug companies, the ones that are responsible for the glut of opioids in your community. One of those drug companies is Johnson & Johnson, or Janssen. Janssen is the subsidiary of Johnson & Johnson that is responsible for the manufacture and misleading marketing of certain opioid drugs. As a result of the work we have been doing and the pressure we have been able to create, they, to their credit, agreed to a settlement which is not only favorable for the county, but is the best of its kind in the nation. Johnson & Johnson agreed to pay to the entire state of Texas and all of its political subdivisions an amount of $268 million. You hear the number $297 million. That also involves certain types of funding that they have agreed to front. But the actual amount of monies that will be dedicated specifically to opioid harm reduction is $268 million. I'm here today to recommend to you that you accept the settlement in relation to the county with the understanding of a few things. One, this is just one of the defendants in your case. This is not the whole case. And the only party that will be released are these Johnson & Johnson entities. We will continue to prosecute the claim on behalf of the county against the other corporate supply chain defendants. Secondly, one of the many advantages of this particular settlement is that it is to be entirely funded this year, which means as soon as the comptroller sets up shop for the purpose of distributing these monies, they should be available at least in the early part of next year. There is no other settlement in the country with Johnson & Johnson which purports to do that. Not only that, but all of the money is going to be administered in the state of Texas by our state court judge and by our state controller. There was a proposal you may have heard about where the attorneys general from around the country, including in the state of Texas, had negotiated a settlement with Johnson & Johnson. This settlement is much more favorable than that, and to their great credit, the Office of the Attorney General of the state of Texas joined with us in negotiating this better settlement. And so this is the settlement that we are recommending to you. It is the one that is the subject of the resolution, which is the settlement which was signed off upon on October 18th of this year. What does this specific settlement mean for the county? It means the following. A direct payment to the county to put to whatever uses the county deems appropriate is estimated to be, from this settlement alone, $18,591. Additionally, the county, which is part of Healthcare Region 1, will have access to a total amount of money that has been cordoned off specifically for the counties in Healthcare Region 1 of approximately $10,063,524,000. The difference between those two sums in terms of how they're accessed is as follows. The amount that is a bit over $18,500 approximately is a direct payment to the county specifically to be used as it deems appropriate. The amount of $10,063,000 and some change that is available to the healthcare region is going to be available by grant application and is to be specific to opioid-related prevention or education or treatment programs. In other words, the county would work with other counties in its region and apply for that sum of money or some portion of that sum of money for the purpose of an opioid-targeted reduction program. That money is to be doled out and initially administered by a group of health professionals called the Texas Opioid Council. Because this is the first settlement, they have not yet formed for the purpose of setting forth their application process and then publishing it. As soon as they do, we will make it our business to let the county know they're open for business for grant applications. Here's the process as they have explained it. We're here to help you sort through how to apply for this money. What I want to emphasize is that sum that's a bit over $10 million is specifically for your healthcare region. It is not, I guess what I would say, theoretical. It is not to be allocated to another region. It is there for the appropriate taking through grant application. So that is the sum and substance of what is available to you. One of the other reasons this settlement is particularly favorable to our clients is the way our attorney's fees and expenses are paid are different than with our underlying contract that we have with the county, and will result in the county paying either nothing to us or something that is substantially less than the contingent fee described in the contract. Here's why. Because under the work of the Texas term sheet, which are healthcare metrics and other agreements that we, the political subdivisions, reached with the state of Texas back in May of 2020, our attorney's fees are to be handled differently than they would be with our underlying contract with the various counties, including yours. More specifically, when you accept a settlement, with respect to that settlement, we waive our underlying contract. And our attorney's fees, not just mine, but all of the attorneys for all the state of Texas who work on these cases, are capped at 9.3925% of the total, plus our expenses. If the AG settlement, which is not the one we're doing, but if the AG settlement does go through, part of that settlement is the creation of a national fee fund where Johnson & Johnson underwrites attorney's fees and expenses up to a certain amount. Under the operations of the Texas term sheet and this particular settlement, we would go apply for our attorney's fees from the national fee fund. We've done a substantial amount of work against Johnson & Johnson. It's created a lot of pressure, enough that it's resulted in this settlement, which, as I say, is the most favorable of its kind. That's the story we'll be in a position to tell the arbiters of that fee fund. And we will say, look at all the work we did, make us whole out of the national fee fund so that our clients should pay us nothing for this work and they can net the most for the best uses. If they short us in any respect of fees and expenses, then up to our capped amount, we have the ability to go recover from the other large funds, which are the total county fee fund up to a certain amount and the abatement fund up to a certain amount. What we don't do is ever come to the county and say, write us a check for anything. And so what happens is, if we are shorted and have to go to the larger funds, your share of how we're made whole is diluted by the other 254 counties and the 1,216 cities that stand to take under the terms of the Texas term sheet. So under any fact pattern, you do better under this settlement and you pay us less, if anything. So those are the most key aspects of the settlement and why we're recommending it. And now, if you have any questions or concerns, I'm here to answer them.
Okay, Jeff, I've got an email from Reed Martin, and Reed and I have talked a couple of times, and this email is dated October 20th. And although it's emailed to me, it begins with Judge Williamson, comma, and I'm assuming that was a typo and that it should have been my name in there, but the talking points that are addressed at the bottom of this email, and I don't see that you're included on this email, so you may be at a disadvantage, but it says, is the fifth bullet point of the talking point says Titus County approximately $32,750 directly to the county. Why does that differ from 18,591? Did I get the wrong email, or did the amount change, or what happened?
The amount didn't change. You got the wrong email. With all due deference to my friend and colleague Reed, I think he determined later that he had not worked through the schedule on the Texas term sheet, but rather had looked at the sheet relating to population in Schedule E.
Okay.
And so I bet if we looked, we would see that the population that is ascribed to the county is that 32,000 number. What I can tell you is as follows, that the amount that is determined to be the direct share, as well as the amount that is available to the healthcare for the healthcare region, is a amount that is simply a math formula, which is that there are health metrics which are publicly available, now part of peer-reviewed literature, that allow us to approximate the total dosage of opioids that went to a county over a period of time, the opioid overdose death rate that occurred in a county at a particular time, the opioid use disorder rate, that is the addiction rate, and also its population. Now, rural counties, counties that are not large enough to have a medical examiner, have been disadvantaged when relying solely on national data. And that's because without a medical examiner, that number is too often underestimated, especially in terms of the overdose death rate attributable to opioids and any extrapolation of the opioid addiction rate from that death rate number. We consulted the leading health economist in the country, Dr. Christopher Rue, who developed an algorithm which has now been accepted throughout the country by experts in health economy for solving that problem. In other words, by how much does not having a medical examiner underestimate the opioid death rate? And he built that back into the calculus, which was then adopted by the state of Texas. And therefore, the health metrics, which determine what percentage of each settlement any county would get, are based on ones which are most favorable to rural counties, at least in comparison to any other. And so the number that came out is this number that is 18,591. And as I say, Reed was simply looking at a different chart.
Okay, thank you.
Yes.
If the county said, no, we're not interested in doing this, what other options do we have? In other words, why would anybody say no to this?
The reason not to say no is threefold. First of all, there are 3,000 political subdivision claims in the country. None of them move very fast. In other words, it's very difficult to get these cases up for trial. It takes years to do so. It is a taxing effort for the county to produce all of these documents going back all of these years, to produce people for deposition, including all the elected officials, the county commissioners, the district attorney, and all of it. I know this intimately because we've been doing this in Dallas County now for the better part of 3 years for a trial setting that is in January. So if Titus County were to reject the settlement, it would essentially remain in the back of the line to ever get its case against Johnson & Johnson up for trial. And if it does so, ultimately, it will be expending lots of time and resources. Number two, Johnson & Johnson is not a good bet to wait around on. I also know this all too intimately, and here's what I mean by that. Johnson & Johnson aggressively uses bankruptcy law to try to avoid paying long-term financial commitments. One of the areas in which my firm has pioneered is representing people who develop cancer from the asbestos in talc-based products. Talc is a mineral mined from the earth used in cosmetic products. And unfortunately, in the same geological deposits that we find talc, we also find asbestos. Because asbestos is microscopic, there is no way to weed it out. So unfortunately, for many decades, Johnson & Johnson sold talc-based products that contained asbestos in them, but consumers didn't know that. As a result of that fact, mothers who powdered their children and children who were powdered by their mothers, in some instances, over years, developed cancers from the asbestos in that talc. We were successful in prosecuting cases on behalf of clients, won some trials against Johnson & Johnson. And Johnson & Johnson came to us and a few other firms in the country and said, How about we settle all your cases and the future cases for your clients who are willing to accept settlement? And in exchange, you don't prosecute cases against us in trial anymore. Our clients determined uniformly that's what they wanted to do. About 10 minutes after we signed the deal, and certainly before the ink was dry, Johnson & Johnson began threatening to spin off its talc-related liabilities into a corporate carcass and put that carcass in bankruptcy in a state that was favorable to corporate debtors and leave us all hanging on the long-term financial commitment they made to us, which is exactly what they did a year later. So the idea that Johnson & Johnson will just hang around and be there for trial later if you reject the settlement, I believe from experience, would be putting hope over experience, and I caution you not to do it. The third is that while no deal is perfect, this particular deal, as I've said a couple times, is the best of its kind. Let's get this one done now. There'll be hopefully other settlements using the same template, which provide more direct payment and certainly a very large healthcare region share. Getting this one, especially with this company, a bird in the hand now, in my estimation, is clearly the way to go.
Jeff, why do you think that they won't pull a bankruptcy stunt on this one?
I think they will, but not before they have to fund the qualified settlement fund before the end of the year. They won't do it that fast because they do want their AG deal to work. And that deal doesn't take officially until February, although Johnson & Johnson has the right to walk away from it. So the beauty of this is the money comes in the door out of what I call the future debtor's estate before they take that aggressive move. And once it's in the qualified settlement fund, they can't claw it back.
Okay. Commissioners, anybody have a question for Jeff? Anybody who's inclined to not want to accept this? I'd like to hear your thoughts on that. Okay, Jeff, how many other large companies are there that are still being sued?
We are currently negotiating with the 3 wholesale distributors that are responsible for most of the distribution of opioids in the state of Texas and in local communities. And we are negotiating with them as one entity. If we successfully negotiate that settlement, it'll be 4 times as large as this one. We are also negotiating with a financially distressed company called Endo Pharmaceuticals. If we make that deal, it will be less, significantly less. But the reason we're willing to make it is for 2 reasons. One, they are responsible for a much lesser profile of branded opioid drugs. And secondly, they are financially distressed, and we want to get their money in the door, paid 10 minutes ago, before they file for Chapter 11, which I view to be a virtual certainty. So the simple problem that we have over and over is the drug companies created a problem so big that there are not enough corporate resources to manage it. And therefore, the idea, at least for my clients, is let's get what we can. At least not what we can, but what we should get compared to any other settlement. I want all of my clients to get at least most favored nation status in a total settlement compared to any other settlement from any particular company anywhere else in the country. And the defendants are well aware that that is our position, that Johnson & Johnson did agree to do that, and I think there is enough impetus to believe that we will achieve those deals with at least those 2 other defendants. Obviously, I can't guarantee it, but the short answer to your question is I'm cautiously optimistic as to both.
All right. I have one last question. This email that I referred to you from Reed on October 20th brings Purdue's name into this. It said,
yes,
in open session, consider and take necessary action to approve settlement agreement between Titus County and Johnson & Johnson, comma, County of Titus versus Purdue. So why,
yes,
why is that mentioned there, and yet we've not talked about that, and it's not included in the resolution?
It's topical and it's prescient. We sued Purdue Pharma in your case, and they then filed for bankruptcy to avoid paying claims in the tort system. And so they consolidated all their debt in bankruptcy, found a very favorable judge, and did exactly what I believe Johnson & Johnson will do, and certainly what I know Endo Pharmaceuticals will do. So it is simply an example of the fact we sued them, and then they filed for bankruptcy, and we have filed a proof of claim on behalf of the county's on behalf of the county. And when that bankrupt trust begins dispersing proceeds, Titus will get some. But it's a slow process. It'll be pennies on the dollar compared to what they should have paid in the tort system. And so it is simply informing our decision as to these others that are in the tort system but don't plan to be there very long.
All right, thank you.
Of course.
Unless there are any other questions, Jeff, I'm going to end this phone call with you. I'm going to read the resolution here, and I will contact you back if we have any last-minute questions come up.
All right, very well. I thank you, everybody, for your time. I'm always here to answer questions. It's my privilege to do so. Upon voting the resolution through, if you will sign the release, which is that Exhibit A document with your signature block on it, and email it to me, we'll make sure Johnson & Johnson gets it in time.
Great. Thanks for your time.
Thank you all. Appreciate you. Bye-bye.
Okay, let me read to you this resolution. Be it remembered, at this date, Commissioners Court, the resolution was adopted. Whereas Titus County obtained information indicating certain drug companies and their corporate affiliates, parents, subsidiaries, and other defendants, as may be added to the litigation, have engaged in fraudulent and or reckless marketing and or distribution of opioids that have resulted in addictions and overdoses. And whereas these actions, conduct, and misconduct have resulted in significant financial loss to the county, and whereas the county brought claims against defendants in the opioid supply chain on behalf of the county, and whereas on October 17th, Janssen and the Johnson & Johnson defendants in the opioid litigation brought by the county, the state of Texas, through the Office of the Attorney General and a negotiation group for Texas political subdivisions, entered into an agreement entitled Janssen Texas Statewide Opioid Settlement Agreement and Term Sheet, hereinafter referred to the Janssen Settlement. Whereas Special Counsel and the State of Texas have recommended that Titus County Commissioners Court support the adoption and approval of the Janssen Settlement in its entirety, now therefore be it resolved that we, the Commissioners Court of Titus County, support the adoption and approval of the Janssen Settlement in its entirety, and authorize County and Special Counsel to execute the release at Exhibit A of the Janssen Settlement, and find as follows: there is a substantial need for repayment of opioid-related expenditures and payment to abate opioid-related harms in and about Titus County, and the Commissioners Court supports in its entirety the Janssen Settlement. The County Commissioners Court understands that the purpose of this settlement to effectuate resolution of the opioid litigation against Janssen entities. We also understand that an additional purpose is to ensure the effective means of distributing any potential settlement funds obtained under this settlement in Texas and under the jurisdiction of Texas courts in a manner and means that would promote an effective and meaningful use of the funds in abating the opioid epidemic in this county and throughout Texas. That's all I can tell you about this subject, but I am asking for your vote as to whether or not you want to support this and sign this resolution.
I'll make a motion, we sign the resolution, support it.
Motion is made by Commissioner Fitch in support of this settlement with Janssen and for execution of the resolution.
Second.
Who said that? Second by Commissioner Applewhite. Any further questions, comments, discussion? All in favor say aye.
Aye.
Okay. Okay. And go ahead and sign this. It needs a signature from all of you. Instead of precinct, they've used the word district, so scratch through the word district and put PCT period if you would, and sign your name above your appropriate line. All right, let's go backwards here. Let's go to item number 4, discuss the renewal of the Printworks lease. This is the leased space in the northwest corner of the Annex. And I'm just bringing this up as a discussion point. We don't have any urgency to take action today, but I do want to bring to your attention that nice corner over there, right next to adult probation, has been leased for the last 4+ years by Printworks. We entered into a lease with them that began January 1 of 2018. At the beginning of that, we gave them some free rent. We replaced some side window. We spent about $15,000. We used our money to replace side windows, to fix a firewall, a door opening, holes in the interior wall. We installed an electric meter outside the building for that space. We insulated the ceiling. We replaced an air conditioner, 4-ton air conditioner with a heat pump system, and we gave them free rent from June 26th of 17 to the end of 2017. So basically they got 6 months of free rent. They got those improvements done, which needed to be done. Now they spent quite a bit of money on their part to get the building usable for their purposes. And then we began a lease that initially was 2 years, began on January 1, 2018. So we're coming up on 4 years, and they have been paying $500 per month. So I'm just letting you know about that. I think that the downtown area has improved significantly. I'm certainly glad we did that project. I'm glad to have them as a tenant. They've been a good tenant. I have no complaints whatsoever. But I do think it's time for a rent adjustment or anything else that you might have in mind. I have no desire to squeeze them out of that space, but I do think that it's time to bring the rents up to what current market is. And I don't know what current market is. We could certainly get some professional help, but my personal opinion, it's somewhere between $800 and $1,000 a month. And I have not discussed any details with the gentleman that owned this company, but I did tell him that it was going to be on our agenda, and they obviously don't want us to make this an onerous burden in the level of lease increase that we do, but I think that we can work this out. So I'm asking you, do you want to do anything? Do you want to do nothing? Do you want to throw out a number? Do you want to have somebody else help us with that number? What would you like to do? But I do think you need to make some kind of an increase in that rent.
I think we need to go up on it myself. I'm not sure what to go up on. I didn't check with anybody local to see what the going rates are around the square, so I need to do some research on that unless anybody knows any other figures on the square.
Well, would you say that, in summary, you're willing to continue to work with Printworks, but you do agree that there's a rent increase in order, and you might like somebody with more knowledge of the current rates to help us with that decision?
Yes. Yes.
Anybody have any other idea than that?
I feel the same way.
Why don't I then do some thinking and talking with 2 or 3 other folks and see what their idea might be, and maybe I'll bring back to you what they think is a fair price on that spot. Yeah. Okay, somebody put that in the form of a motion.
Make a motion, we research what our options are on the lease rent for print works. Get back possibly next meeting.
Okay. Motion by Commissioner Fitch to
Second.
research what market values are in the area. Second by Commissioner Parchman. Any further discussion? All in favor say aye. Item number 5, consider and possibly approve a 2-year warranty extension, system test, 4 additional duress alarms, and all new batteries for the county's SecureTech panic alarm system. And this will run us about $2,590. Let me give you a little more breakdown on that. Where's my sheet? I know you put it in here, James. Paul and I were just looking at it. I think that the warranty extension is necessary. It covers all components. Here it is. We're going to replace the rechargeable battery in the main control unit, replace 62 batteries at a cost of $6 each, $372, a new battery, 3 new batteries for the repeaters, total of $117, service and test the complete system, $575, a 2-year warranty extension, $995, and then add 4 new alarms for different locations that don't currently have a duress alarm at a cost of $125 a piece. Total $2,590.25. This is one of those deals that you don't realize how valuable it is until the day comes when somebody needs help and doesn't have any other way to shout out for help. This one is we each have a button in our offices throughout the county that sends a signal to several people by phone. I get a notification, Paul gets a notification, sheriff's office, the constables. In other words, you got a lot of people that are aware that there's a problem if you press that button. So I would sure like to see us give this thing a tune-up. $2,590. Unfortunately, I wish I could tell you that we had money in the security fund, but because we don't have as much money coming into that fund as we used to, and we spent a good bit of it in the last year, Barbara has found another place to pull that money out of without drawing it from contingency. And I would like to, and that is I don't even understand it, and I'm the county judge. This is the county judge's state supplement fund, and I don't know how money builds up in there, and I don't get it, but maybe you can explain how that works.
Yes, sir, I can. The state sends us a supplement for the county judge's salary. They send it to us annually between October and January each year. In 16, we got about $1,700. In 17, we got about $1,800. In 18, we got about $1,600. In 19, we got $3,700. And in 20, we got about $2,000. We should be receiving another payment for that shortly. We've not yet received it this year. Those monies have been used for some travel, some other security type items, a TV in a safe, some kind of document feeder back in 18. And the AEDs, the defibrillators, similar type items.
So we can pay for this without any new money and without pulling it out of our contingency fund. That would be my recommendation to you.
I make a motion, we approve.
Motion to approve $2,590.25 to Secure Tech Systems, made by Commissioner Parchman. Second by Commissioner Parker. All in favor, say aye.
Aye.
Thank you. Okay, item number 7, we're going to discuss some main courthouse insurance coverage. This is coverage for our main building here. And Nanette spends many, many hours fine-tuning and making sure our insurance coverage is adequate throughout all of our facilities and all the equipment that we have. This is a letter from Kelly Flores with Texas Association of Counties. Asset Works, that's a third party that they negotiate with, has completed the reappraisal for your historical building. Your property coverage with the pool provides historical reconstruction for historical buildings. Historical reconstruction means the cost to repair, rebuild, or replace with materials of like kind and quality comparable to those originally used, including the cost of skilled labor and authentic materials necessary to restore the property as nearly as possible to its original condition. It was determined by Asset Works when valuing historical buildings that they're using a methodology known as historical reproduction, which is simply using new materials and not contemplating the cost of skilled labor. Historical reproduction cost is a less expansive valuation and does not consider all that historical reproduction cost does and is not offered by the pool for historical buildings. Our coverage intent for historical buildings has always been to provide historical reconstruction. The pool's historical reconstruction cost is available for members who select historical valuation and want the ability to reconstruct historical buildings using those authentic materials and skilled labor. Find attached your updated values for your historical buildings, which now reflects the historical reconstruction value. So, if you were to go with, in coverage specifically, this courthouse, it sits on the square, the valuation at historical cost, again, using all these authentic materials and methods, which may or may not be the most technologically advanced, that historical cost is, for this building valuation, $11,722,000. $11,722,000. Replacement cost, which again would be the cost to, what would you do if you were going to build a new building here with the same functionality but not using these historical construction materials? $4,548,800. And then the contents value, of course, remains the same. So again, do we want to pay for historical cost coverage so that we could put this thing back exactly the way that it sits right now, or do we want to use replacement cost? To me, this is a no-brainer. I think that we could produce a very high-quality, aesthetically pleasing to this community and this downtown square. We could even give it a historical look and flair without committing to the historical cost where we use all this expensive lath and plaster, et cetera, and bring in the artisans that would be necessary. But that's just my opinion. I think that adequate coverage would be appropriate if you chose replacement cost.
I like the replacement cost. I don't see, as beautiful as this courthouse is, dedicating that much money to it to make it that so beautiful again.
I'm not even
once
sure that
again.
it's all that beautiful. You know, I beg to differ with you, but
We love stucco here in Titus County. We love it. So,
Well,
no, I like the idea of the lower cost. There's no, our historical brick and mortar in this building is pretty weak. So, yeah, it's a no-brainer. Go with the.
anybody see it different?
Courthouse
Want to talk about
insurance.
that? Okay, would you make that in the form of a motion so that I can tell Nanette what to tell TAC?
Let's make a motion that we cover the courthouse with replacement cost insurance.
All right, motion by Commissioner Fitch. Second, Commissioner Parker. Further discussion? All in favor, say aye. Item number 8, consider and possibly approve holidays for 2022. You have a list there before you, hopefully. Well, then I'll tell you what they are.
Okay.
I will tell you up front, there is a net addition of one holiday. That is Juneteenth. And that will fall on Monday, June 20th this year is the recognized national holiday. So what I'm telling you is, if you so choose to approve this schedule, I have laid out for you the previous existing holidays, and I have added June 19th. Now, if I add June 19th, you may want to take away one somewhere else, but let me read the list here. We've got New Year's Day, which would be this coming up, which falls on January 3rd this year because the 1st is on a Saturday. Martin Luther King Day, President's Day in February, Good Friday in April, Memorial Day in May, Juneteenth in June, Independence Day in July, Labor Day in September, Columbus Day in October, Veterans Day in November, Thanksgiving 2 days, Thursday and Friday, and Christmas Eve and Christmas Day holidays for end of 2022 there on the 23rd and 26th because Christmas falls on a Sunday. So again, my list here includes a net add of one for Juneteenth.
Make a motion to accept it.
Motion is made by Commissioner Applewhite to approve these dates for 2022.
Second.
Second by Commissioner Parchman. Any discussion? All in favor of approval, say aye.
Aye.
Item number 9, consider and possibly approve the Commissioners Court schedule for 2022. And there are no real points of discussion, I don't believe, here. Using our regular 2nd and 4th and making adjustments where needed. It turns out, according to James Webster, who has studied this carefully, tells me that we only need to make a modification there in October on the 7th and bump that Monday back to a Friday, and then bump because there is a holiday the day after Christmas, the 26th, he recommends bringing it back to Thursday before our normal Commissioners Court there on Monday, so we have that out of the way before you come back and have a meeting on Tuesday after you've enjoyed the Christmas holidays. So we could go either way there, but I trust James's wisdom in his recommendations. And these will be, so essentially the 2nd and 4th Mondays of each month at 9 a.m., except when this falls on a holiday. And again, I've told you there's 2 adjustments there in October and December to bump back to the last day of the business week.
I make a motion, we go with James's recommendation.
Very wise. Motion's made by Commissioner Parchman,
Second.
second by Commissioner Applewhite. Any discussion? All in favor, say aye.
Aye.
Item number 10. Consider and possibly approve issuing a request for qualifications for a grant manager to assist the county with the American Rescue Plan grant funds. Interestingly enough, you heard some information from Sue this morning that makes me wonder, we're going to even want to spend this money. But nonetheless, let's talk about if we find out that we are not hamstrung like we're potentially going to be if we use those funds. The idea of a grant manager has been brought up by Barbara in the past. I think it's a good idea to have someone that would assist us with making sure that we go about the utilization of those grant funds. Now, just because we would put out a request for qualifications does not mean that we would necessarily eventually hire them. We have no idea what this is going to cost us, and who knows, things may change and we may change our mind on using those monies. But I'm going to let Barbara just kind of give you a little bit of what she knows about this. She's done some research here, and there's apparently one company that looks like they've kind of stand out amongst the others, and they've entered into some agreements with some of our other counties within the state. Barbara, what can you add to what I've said here?
Well, the first thing I want to say is I agree with what you talk about, what Ms. Evenwell had to say. I was not aware of those possible limitations, and I think we definitely need to look into that. However, I do know that what we are looking at now is the interim rules. The final rules were due out in September. The federal government has pushed that back to January. So what most counties have done is they have gone out for an RFQ for proposals. They selected a grant manager, and they're moving forward. One reason we had talked about doing this in the budget, one reason I had waited is because of the fact that the rules are now interim. They are subject to change. So we want to keep that in mind. But I also don't want us to get behind if there's something that we could use the money for that meets, our requirements, your requirements. The other thing that's in the budget is also the hiring of a part-time staff member to assist this person, whatever grant manager it is that we determine. Most counties around us have gone with a firm called GrantWorks. I'm not familiar with them. There's another firm called Trailer and Associates out of Tyler, I believe. They're doing a few counties, but most of the ones in our area have selected GrantWorks. The percentage that most of those firms charge is between 3 and 10% of the grant. And further, Ms. Evenwell is correct, the grant is over $6 million. So 3 to 10% is a sizable sum, but that's really less than what you see on a lot of smaller grants, the percentage. It's just that this grant is so large. So my question to you then is, do you want to go out now for qualifications and then wait and see what the final rules are? Or do you just want to wait until January and then advertise at that time? The interim rules are over 27,000 pages. It requires a lot of time and effort and understanding of how the grants work. And no one knows exactly how this one works because we've not had one like this, I don't believe ever. And if we have, it was certainly before our time. So it's hard to know what the right thing is here.
By the time you posted and gave everything the adequate amount of time, what's the soonest you could schedule interviews with potential candidates? First of the year?
Yes, 6 weeks really is a tight timeline. We could do that. I mean, we can request that those things be turned in. We could wait 60 days if we wanted to. Give us time and you time, Judge, to do the research. I don't have the ability to look at the legal issues that go along with that. I think you're right, the county government's a good place to start.
Well, my thoughts are, regardless of what we're thinking now, if we might possibly consider turning these funds down, the sooner that you get aligned with, or the sooner you begin this process, you gain knowledge in the process, and maybe one of these grant companies can, enlighten us. I'm sure they're going to obviously be pushing us to take that grant money because they want to manage all that money for us. But I think I'm tempted to delay this just a little bit, and I want to get the Council of Governments, our ATCOG, looking at these stipulations here that are included in this contract and find out, I don't want to be blindly seriously considering and get involved with a company who understandably and fairly needs to be paid, and I don't want there to be any obligation on behalf of the county if we were to, for some reason, decide not to take those funds. So why don't we wait just a little bit here? If we could put all that together. And when do we expect the final regs to be out, have they said?
We expected they would be out in September, and now the federal government has moved that back to January. So, I hesitate to, I can't guarantee they're going to be out in January. It could be March. It could be May.
Yeah.
Now, these funds run through December of 26. That's when you have to have expended your money. You have to have encumbered your money or ordered your products, whatever it is you're going to do, by December of 24. So I think we have time to wait and even request the qualifications February, March, make a decision April or May. But I agree with you. I think it's important we have the final rules in place instead of...
Well, and that's not even so much what's keeping me from moving forward. I think that I want to know more about our obligations. The last thing we want to happen is for the federal government to be saying, hey, you owe us money. So I think this is a great idea. I do support that. It's a staggering amount of money, and I want to see, this thing was originally designed to be simpler than your typical grant. So does it still warrant 6 to 10%? I don't know. That's I don't know. I have not talked to another judge in our area that has contracted with GrantWorks yet. So, anyway.
I know Kent County has. I know Morris County is out for bids now. I believe that Hopkins County did. I can get you a list, Judge.
Okay.
Franklin County chose somebody. I'm not sure. I can't remember who it was.
Okay.
There are several counties who've already gone with the grant administrator.
Okay. Well, I just haven't talked to him about it. All right. Well, let's. I'd like to see us table this, if you don't mind.
Make a motion to table.
Motion by Commissioner Parker.
Second.
Second by Commissioner Applewhite. All in favor, say aye.
Aye.
And just FYI, at our next meeting here on the 22nd, I've got a gentleman that Commissioner Fitch and I have been talking to with People's Telecom, who is going to talk to us about a potential way to use grant funds to expand our infrastructure to enable more people within our county to have broadband access. So again, we're going to certainly listen to him, and the only way we could pay for the kind of services that they're talking about would be to utilize some of these ARP monies. But he's still on track to come. We're going to listen to him next month, but we're certainly under no obligation there. Item number 11, it's time for approval of the quarterly investment report. Is our money still safe and sound, and you're still keeping it wisely interest earning? Is that right?
Well, I'm keeping it as wisely as we can earn interest and keeping it safe. All of our funds are at Guarantee Bank. Our interest rates are significantly lower than our last contract, but that's how interest rates are.
Any other changes in methodology or moving of money? Doesn't look like to me there is any changes there.
I make a motion, we approve them.
Motion to approve the quarterly investment reports made by Commissioner Parchman. Second by Commissioner Parker. Questions, comments? All in favor, say aye. Aye. Thank you for doing that, Barbara. Item number 12, approve oral and written reports.
Make a motion, we approve the reports.
Motion to approve is made by Commissioner Fitch
Second.
and second by Commissioner Parchman. Any comments or questions? All in favor, say aye.
Aye.
Need your signature. That's the quarterly investment report, and this is the second report we just approved. Right behind that, we have the treasurer's report in item number 13 for your consideration.
Make that motion.
Motion to approve the treasurer's report is made by Commissioner Applewhite and second by Commissioner Parker. All in favor, say aye.
Aye.
There's that one. Item number 14, approve budget amendments. You'll recall at our recent meeting, we made some changes to the district attorney staff budget by increasing his assistant DA's salary, as well as his 2 support staff members, and he was going to be paying for this for the most part out of his forfeiture fund. The net impact here, which is laid out for us, pulls $1,815 out of our county contingency account. So that it doesn't affect our overall budget, but it is a use of funds that was set aside without any specific designation. $1,815, and then that increases the DA's assistant, her salary by $5,000 and the support staff by $2,000, along with FICA, Medicare, and retirement. He also had a $5,000 increase to his travel and seminars. So he's pulling the majority, all but that $1,815 out of his forfeiture account. So that is the one budget amendment that I've got.
Make a motion, we approve the budget amendments.
Motion is made by Commissioner Fitch,
Second.
second by Commissioner Parchman. All in favor, say aye.
Aye.
Item number 15, sign pay orders and approve payment of bills. Motion by Commissioner Parker.
Second.
And second by Commissioner Applewhite. Is there any discussion? All in favor, say aye.
Aye.
Closing comments. Thank you to those that commented today. We appreciate that and we encourage that. Glad to hear from Colton House. We will likely begin discussions with the city after the first of the year, gearing up towards the renewal of a city/county fire contract. That will be, I promise you, a lengthy process. There will be a lot of information to digest and weighty decisions to be made. So I've asked the chief to plan on getting the necessary parties together. I'm sure that will include chief and city manager, and we'll probably hear from volunteer fire departments as well as city council members. That is, that's all I have. Commissioner Parker?
Just like to update on the chipper. We got ours back Thursday, and everything supposedly good on it, and we've still got to calibrate it, but that's not a big deal. That's where we're at on it.
Okay, thank you. Good deal. And the other one's been returned, the rental unit?
Yes, sir. It was returned a week before we
Commissioner Applewhite.
I'd like to say, send out prayers and thoughts to the Vandiver family for the loss of Brother Vandiver. It had a heart attack last Wednesday night, week before last, rather, and have prayers for their family.
Thank you. Commissioner Fitch.
I'd like to send my prayers out, condolences to the Vandiver family and the Sugar Hill community. We lost a true servant there. He served the Lord, and he served his community also, Brother Vandiver. Thank you.
Commissioner Parchman.
I'd like to thank Ms. Evenwell for coming today, speaking, and having very helpful information that you brought to us today. Thank you for that, and thoughts and prayers to the Vandiver family as well.
All right. That brings us to the end. If you're ready to end this meeting, I'll need a motion to adjourn.
Make that motion.
Motion made by Commissioner Applewhite, second by Commissioner Parker. All in favor, say aye. Aye. Thank you, everyone.